Right now, voting districts are determined by the total number of people living within the district. Those districts are mandated to be equal in population size. Instead, this case argues voting districts should be determined by the number of eligible voters. Here to explain the impact of this kind of change and how it could have an impact on minorities and California's political structure are my guest, political science professor Carl Luna and constitutional law expert attorney Dan Eaton. And Dan, the plaintiffs in this case claim that the current method of determining district boundaries are not equitable. What are the arguments they're making to support that claim?
Peggy, the plaintiffs are saying that, look, you need to determine districts by voters, not by raw population, because when you determine it by raw population, which includes ineligible voters, includes eligible people, then we have a problem because voter strength is diluted. They say, look, raw population, which is what many circuit courts have held is the appropriate way to determine districts, is a wrong standard because it dilutes voter rights. And under the Equal Protection Clause of the Constitution, they say that is wrong.
So that's what's at question, but what about racial composition of voting districts? It's often the focus of legal actions. Tell us about the Voting Rights Act and how it's supposed to protect racial minorities.
Right, the Voting Rights Act, of course, was enacted in 1965 and was derived from the 15th Amendment of the United States Constitution, which prohibits states from enacting laws that impair voting based on race. And what it does is prohibit states from enacting laws that impair voting based on race or language. And that's the bottom line. That issue is not here before the court. This is a very different question. This is whether, as a matter of structure, states are permitted to decide districts based on overall population or whether they must decide it based on citizens of voting age population.
Well, Carl, aside from it not being the question, certainly this if this ruling goes in favor of eligible voters, it would change the racial minority makeup of a district, or would it?
Well, it's going to affect race, it's going to affect age, it's going to affect income distribution. The younger, the poorer, the less white you are, the less you're going to be part of the apportionment, because that's the portion of the population that if you're under 18, you can't be eligible to vote. Illegal immigrant, not eligible to vote. Populations that are younger with more kids, that's going to be diluted out. You're wealthier, you're older, you're more likely to be eligible to vote. I don't think it's a coincidence that this is being put through by a political party, this challenge, that would benefit under these circumstances.
Well, before we get to that, why do you think it would pan out that way? Why would it be that older white people would get more representation than minorities?
Well, take the county of San Diego, should you adopt that here. If you go out into the county, you're going to have an older population, a whiter population, a wealthier population. The odds that these are eligible voters is simply going to be higher than if you're in Southeast San Diego, if you're in the urban areas of San Diego, where to begin with, you'll simply have more kids. A household with children is not going to be counted as much as a retirement household.
Do you agree with that, Dan?
Well, it depends on how far the court goes. If it agrees with the plaintiff's argument, doesn't it? Because the question is exactly what does one person, one vote mean? And there are any number of ways the Supreme Court can define it. And the fact is, since its landmark decision in 1964, Reynolds versus Sim, the Supreme Court has not yet clearly defined it. And that's why this case is being reviewed now.
And I'll ask both of you this, starting with you, Dan. Aren't elected officials supposed to represent all people in the district, whether you're of voting age or not? They're supposed to represent the people in that district, right?
Well, certainly the Ninth Circuit in a 1990 case involving the supervisorial districts in the county of Los Angeles felt so. They said so in a footnote, but this really gets to a basic issue of what the Constitution means. Are we talking about equality of representation, or are we talking about electoral equality? And that's really the tension at the heart of this particular lawsuit, Peggy.
And Carl, would you say that is true? How would people be represented if this law went through?
Well, on the surface, there is a constitutional theoretical debate. And is it the trustee model where you vote for the people, or the delegate model, you vote for the ones who brought you in as a representative? I see this as a part of a tapestry which is saying a certain group in America is not doing as well under current demographic changes. This is a move to reinforce my side while I still have the time to do it. Bottom line, no matter how you slice and dice it, I tend to think if you're older, whiter, conservative, you will do better with this if the Supreme Court even allows it in states. Now, if you would benefit by having it one man, one vote, where everybody gets counted, the plaintiffs would have been on that side of the equation to see it to benefit them. There is a political end to this, whether or not it's a constitutional question.
And we'll have to end on this. Do you think there's a political end to this?
This is ultimately a constitutional question, and the court is going to decide it on constitutional grounds.
All right, Dan Eaton and Carl Luna, thanks so much.
Thank you, Peggy.
Thank you.